We are still talking about equal protection, but just to break this up a little, we're now moving on to legislation that took place after Brown versus Board. The most important thing about Brown versus Board, not only did it desegregate the schools, but the court wrote that separate but equal is inherently unequal. And so that creates a new interpretation of the Equal Protection Clause. And now we'll see further court decision and legislation based on that idea. So it's not just like only applies to the schools and things like that, but we're going to see the government start to take more action to resolve some policy problems and to start using this new interpretation of equal protection of the law. So the most important law that Congress passed in the civil rights movement is the Civil Rights Act of 1964. So this is President Lyndon Johnson, after the death of President Kennedy, with cooperating with Martin Luther King and different social movements, trying to solve some problems here. So the Civil Rights Act, a huge piece of legislation, passed despite the fact that we had some racist senators go on and filibuster for more than 24 hours and all this. But the Civil Rights Act says that racial discrimination is illegal in places of public accommodation. Congress passes this law because this is based off the Commerce Clause. Remember, way back to the Commerce Clause, Congress has the power to regulate interstate commerce, which means that they have the power to tell businesses that do interstate business how to operate. So this is what the power that Congress will use to end this Jim Crow era of laws. So racial discrimination is illegal in any place of public accommodation, any business that is like open to the public. This will forbid discrimination in employment. So you can't just like only hire white people or whatever, but this went beyond just race. It went race, color, national origin, religion, gender. It created the Equal Employment Opportunity Commission to enforce these kind of things against jobs. So it set up a new bureaucratic agency to make sure that there was not discrimination in hiring and things like that. And to like enforce this, any institution that discriminates won't get any federal money. So this is a way that they're able to, even though the national government doesn't tell you how to run your schools, here this is like a version of a categorical grant where they're like, if you don't follow these laws, you're going to lose all of the money that we give you for these sorts of things. So the national government taking a very active step to end official state government discrimination here with the Civil Rights Act of 1964. They kept working, and the very next year they issued the Voting Rights Act of 1965. This we'll take a look at later with our voting stuff, but this is the most important voting law that we have, and this was also highly effective. So this prohibits the government from using procedures that discriminate. That is a much bigger step than the 15th Amendment, which just says you can't stop people from voting because of their race. So things like the literacy test, the poll tax, those were not racial policies. They very specifically weren't, right? Like that's why the states use them, but they had disproportionate impact on black voters. So the Voting Rights Act ends those practices that discriminate. They end the literacy test. They end the poll tax. They also gave the federal government the ability to like send monitors to the states. Remember way back in Unit 1, the states handle elections. This allowed the national government to send basically referees into areas that had a history of racial discrimination in voting, and the federal government could monitor the states to make sure that they were doing things correctly. And then this last part is the most important part of the law. This is called pre-clearance. This part of the Voting Rights Act said that they identified some states that had problems with discriminatory voting, and places that had a history of this were not allowed to make changes to their voting laws unless they got the approval of the federal government first. So states like Alabama, Mississippi, Georgia, Texas, It went out to Arizona, things like that. So these states that had this history of discriminatory voting practices were not allowed to change their voting laws unless the federal government said that it was okay. And so the federal government would prevent them from passing laws that would have negative impact on minority voters. So states like this weren't allowed to pass things like photo ID laws and all this kind of stuff. Now, in 2014, the Supreme Court struck this part of the Voting Rights Act down, and we'll talk about that later when we talk about voting. But this was what made the Voting Rights Act the most effective law. This prevented Alabama from being able to decide which polling locations they want to close, or to require people to have a photo ID to vote, and all that kind of stuff. So the Voting Rights Act with the Civil Rights Act are the most important legislation we have from Congress that ends segregation. All right, so there's a couple court cases that follow Brown here, and so these work with the Civil Rights Act, kind of do a lot of the same thing here. But first up, we have Heart of Atlanta Motel versus the United States. So Brown versus Board just desegregated the schools, and the Civil Rights Act, said that that places that serve the public could not discriminate and all that. But the Heart of Atlanta Motel was still refusing to rent rooms to African Americans. They wanted to argue in court that Congress did not have the power to tell them how to run their business and to ban private discrimination in this way. Remember, a previous act way back had given private businesses the ability to do so. So Heart of Atlanta Motel wanted to protect its right to only sell rooms to white people. And so now we have a precedent, though. Brown versus Board creates the precedent not just to desegregate schools, but remember it said separate but equal is always unequal. So here they use the precedent in Brown, and they say Congress actually does have the right to use the Commerce Clause in this way. And so the Civil Rights Act is totally legal, and segregation is not allowed in any business that serves the public. And we still have another challenge to the Civil Rights Act in Katzenbach versus McClung. This is about restaurants, and restaurants are small businesses. They're little private businesses and all that, and so they argue that that is an unfair burden to force upon these very small businesses. So in the case here, they once again challenged Congress's power to ban discrimination. And following the precedent from Brown and that same precedent in Heart of Atlanta, the court said that it was okay for Congress to use the Commerce Clause to pass the Civil Rights Act. So since restaurants participate in interstate commerce, they are subject to the regulations of Congress, and Congress says that segregation is not legal there. So we've got a long history here of policy changes that are all dealing with the interpretation of the Equal Protection Clause of the 14th Amendment. All right, and beyond just interpreting the Equal Protection Clause, we have other programs and stuff, and so we want to focus on a handful of cases here that deal with affirmative action programs. Affirmative action programs start popping up in the 1970s as states are trying to correct their past wrong policy. They're trying to take more active steps in making sure that people are treated fairly. And so this is what we get here in affirmative action programs. These are designed to give some special treatment, or what they call compensatory treatment, to a group that they classify as previously disadvantaged. So they're taking some extra steps to make sure that groups that had been discriminated against can achieve a version of equal treatment today. So to try to fix these problems that had been historical problems in employment and in promotion and in admissions, like admissions to colleges and stuff. So for groups that had historically faced discrimination, these states are using new programs to try to make sure that those groups are in a better place today. So one of the things your book will say is this goes beyond just providing the same opportunities for everyone, and this is a step in the direction of trying to achieve equality of results instead of equality of opportunity. So these laws are challenged almost immediately. And our first court case here is the University of California versus Becky. And so what the people suing in these cases, these will be white people suing, and they'll be suing saying that now they are the ones receiving unequal treatment of the law. So they would say that affirmative action programs, since they may give some special treatment to non-white students, that now white students are being discriminated against. And so in University of California versus Becky was trying to get into med school, and he applied twice, and his GPA and his test scores were higher than some of the students who got into the school through California's new affirmative action admissions program. The way that UC Davis had done this is for the 100 seats, the 100 students that they were going to allow into a class each year, they set aside 16 seats for students to get in through this program. So they set aside specific seats and a certain percentage of their admissions for students from from disadvantaged racial groups. And so Becky argues that his equal protection was being violated, that he was not receiving equal protection of the law, that he was denied his spot at the University of California, Davis because of his race. So the court did two things here. They did side with Becky in this instance, but they did also say that affirmative action programs were fine, that affirmative action programs are legal, and those are things that states can do because the government has a compelling interest. The government has a reason to want to achieve diverse schools. So what the court said is that the idea of this policy is good, but the details of this policy are bad. So affirmative action programs are good, but the use of quotas, the fact that they set aside a certain number of seats, that was bad. So this particular affirmative action program doesn't work, but affirmative action programs in general are legal according to the court. So Becky got into college, got into the med school that he wanted to get into, and affirmative action programs were given the thumbs up from the Supreme Court. All right, and so then that University of California versus Becky was the standard for a long time. More and more states started implementing affirmative action programs. More and more states trying to create more diverse student bodies at their colleges. And so in 2003, we have new challenges to those programs. And you'll notice here that the defendant in both cases is the same, Gratz versus Bollinger, Gruder versus Bollinger. These are both suing the University of Michigan. And so Bollinger is one of the admissions officials there. In Gratz versus Bollinger, this was to get into undergrad. And they created an affirmative action program where they were going to give everything that you did a certain number of points. And so they were, if you got 150 points of all the points, there were 150 possible points. And if you got 100, you were going to get admission to the University of Michigan. So your class rank would be a certain number of points. The teams that you were on would be a certain number of points, all that kind of stuff. They were basically scoring your resume. And they wanted to increase diversity of their student body. So for African American, Hispanic, and Native American students, they got 20 points for being from a underrepresented racial group. And so that would definitely help more people get into the school. Now you see here a perfect SAT score is only worth 12 points. So this was challenged in court. This version of picking students for the school was challenged in court, and the court ruled similarly in as they did in the California versus Becky case. They were like, affirmative action programs are good, but this one is bad. Here, giving the bonus points to the students, giving such a big numerical bonus just for being of a certain race was bad. But still, they said that affirmative action programs are good and that there is a reason for Michigan to want to have a diverse student body. So they were also sued the same year by Gruder. So Gruder versus Bollinger. This was for the grad school, and in this case, they were ruling that race was one of many factors included in determining whether an applicant would be like a good student fit or whatever. So they weren't setting aside seats, they weren't like giving bonus points or anything, but they were just vaguely giving special consideration to students from minority racial groups. And the Supreme Court said this program is good. Race here was a factor in the admissions. It wasn't like a numerical factor. It wasn't a automatic bonus or anything like that. But race was one of many factors that the school could use. And so in this case, Michigan's case was upheld. All right, and just a few years ago, Texas was challenged in their affirmative action admissions program for the University of Texas. They actually they thought that they came up with a good way of doing this that would increase diversity on their campus and was pretty race blind. So to get into the University of Texas, if you are in the top 10% of your graduating class at a Texas high school, you get admission to the University of Texas. And so you'll notice that policy says nothing about race, but the effect here will be to increase the admission of students from underrepresented races, particularly Hispanic students and African American students, because we'll have high schools in their big cities, like we'll have high schools in Houston or high schools in Dallas and San Antonio that are like majority African American or majority Hispanic American, and so the top 10% of those schools, those kids will all get into the University of Texas, and Texas will increase diverse admissions without having a policy that deals with race in any way. So Fisher, she doesn't get in. She was at her school, she was top 12%. And she had a 3.6 GPA and 1180 on her SATs. And so her scores, her GPA and her test scores were higher than some of the students who got in from the top 10% program. So she would argue before the court that she was being denied admission because of her race, that she was not getting equal treatment. But in this case, Texas designed a great policy here. Like Texas's policy doesn't deal with race at all, but does create a more racially diverse student body. And so the Supreme Court said this was good. This is a good program. Fisher does not get into the University of Texas, and it does not matter that her GPA and her SAT score is a little higher than some of the students that got in. Texas, just like any other school, has a compelling interest. They have a reason to want to create a diverse student body. So we have a lot of critics of affirmative action programs. We have a lot of people that have problems with these programs. And typically, the criticism here is that people that are critical of these programs would call this reverse racism. So critics would feel that they are now the victims of racism because these policies have gone too far. Now, all of the cases here that we've dealt with here, they've been brought to court by individuals who felt discriminated against because somebody that they think is less qualified than them got hired or promoted or admitted over them and all that. So they did not get into the college of their choice. That was all the cases we were dealing with here. And they would feel that other people that got in shouldn't have got in, and that their place was taken by a less qualified individual. And a lot of states have reacted to these criticisms and motivated people are able to get policies passed. Particularly the two states we dealt with first, California and Michigan. have at the local level passed bans on affirmative action programs in college admissions and other things. So this is kind of where we are now in arguments about civil rights and things like that. All right, time to talk about our bigly ideas for the day. So let's wrap up all of the things we need to make sure we remember from today's notes. We talked a lot about schools today. So here is President Trump visiting I'm sure, a very excited classroom. These kids are busy working on something. And now they're getting some very wise advice from President Trump. And here's President Trump hanging out with his good friend, Lil Wayne. So let's think about the main things we need to do today. We're focusing, of course, on the 14th Amendment, so make sure that you know all about the 14th Amendment. But especially today, we were focusing on the shifting interpretation of the Equal Protection Clause. So we want to make sure we can describe the different ways the Equal Protection Clause has been interpreted. The big court case that we absolutely have to know by name here is Brown versus Board of Education. I know you guys know that one. There's a lot of other ones here that you should know by name, won't be guaranteed to be on the test, but a lot of these like Plessy versus Ferguson and cases like that, Heart of Atlanta versus the United States. So these are the kind of things that pop up on the AP test from time to time too. But Brown versus Board, the main one we need to focus on. As far as the legislation goes, we got to make sure that we can explain what the Civil Rights Act of 1964 is about, and we can explain what the Voting Rights Act of 1965 does, how they work, and their effect on business and things like that. And then finally, we want to make sure that we can explain the goal of affirmative action programs, like why that they're using an interpretation of the 14th Amendment to try to achieve equal results in college admissions and things like that. And so thinking about those court cases and those issues with affirmative action programs. And that's it for today. There's a lot to go through there. A lot of court cases and a lot of policy decisions there, and certainly does not touch on all of the issues that we deal with when we're talking about civil rights protections and particularly focusing on African Americans. But we will continue to talk about some more of these issues, and we will move on from just focusing in on policies from the African American civil rights movement and to look at other social movements and their impact on civil rights protection as well.